Hello, everybody. Good afternoon. Thank you so much for joining our The Need for the DOT Application webinar. We are excited you're here. This has been a very much highly anticipated webinar, highly attended webinar. So I just want to start by saying we really appreciate your time. Thank you for taking some time out of your day to join us. My name is Leah Kelly. I'm here with our CEO, 10th Street CEO Tim Crawford, and 10th Street's General Counsel, Shannon Wheeler. But before I let them take it away, I just wanted to cover a couple of housekeeping items. The webinar will be recorded. You will receive a copy of the webinar within about 24 hours after it ends, so just give that a little time. It will be in your inbox in tomorrow around 2 o'clock. And questions, we welcome your questions. We know this is a hot topic. We had a lot of inquiry about it, so we'd love to hear your questions. Please go ahead and ask them at any point throughout the webinar. You can do that using the questions section in your GoToWebinar panel, and we will answer those at the end. So I think that's it. Shannon, whenever you are ready.
Great. Thank you, Leah. Hi, everyone. This is Shannon Wheeler. I just wanted to give a little bit of background about me. I just started at 10th Street about 10 months ago. And before 10th Street hired me on, I spent 10 years doing business litigation with about a 70% focus on employment law defense litigation. So I represented a lot of companies like you against employment law lawsuits. So I just wanted to mention that at the beginning of this webinar because we're going to talk a little bit about how these changes might affect the risks to your business. Tim and I are just coming off of the user conference in Vegas. We had a great time. It was wonderful to meet many of you. A lot of you told me that you were going to be joining this webinar, so I just wanted to reach out and thank you to all of you who came and who I got to meet. Really encourage everyone, if you didn't come to this year's user conference, to try and make it next year. It was a lot of fun. We had a lot of really great content. We released a lot of really neat information about products we're going to be rolling out, and we had a lot of dinners. We had a fun happy hour, so look forward to next year for sure. Okay, so my famous legal disclaimer, I have to say it, this information is educational information only and does not constitute legal advice. We always recommend that you consult with your own attorney about legal issues, and we have a lot of attorneys that we can recommend. So if you need a recommendation, please reach out and we will get that to you. Right, so as Leah said, we are introducing and today and talking about the Fmcsa's proposal to eliminate Section 391.21, which is the regulation that calls for the DOT employment application, and it has all of the mandated requirements excuse me, that the Fmcsa requires in the application. So today we're going to talk about the details, the potential implications of the rule, the questions that the Fmcsa has specifically asked. We're going to walk through how you can voice your opinion, how you can have your voice heard, and then we are going to take questions. So, yeah. So this is the proposal. I think we posted in the handout section of this webinar the actual text of the notice that was given out by the Fmcsa, which has all the details about their proposal. And it says in it, quote, that they are seeking to amend the Fmcsa's regulations to change or eliminate the entire Section 391.21, which includes the requirement to have prospective drivers complete an employment application. So we've been following this proposal since, middle of last year. I know most people don't read a lot of regulatory notices, and I think that this one has really flown under the radar. So after so much time had passed and we really weren't seeing a lot of comments, we started talking to people about it, getting their opinions, and decided that we needed to write a blog post and really talk about how we think this is going to affect the industry and do this webinar. So just want to say this is, oh yeah, we're going to link also, Leah's sending out right now a link to where you can go to comment. And so you can just click on that link and it will take you directly to the regulations.gov site to this regulation, and you can just type your comment in right there. So we wanted to go ahead and post that right at the beginning of this webinar for you. It's important to note that the deadline to comment is next Tuesday, May 7th. So that's all the time we have. We need people to go comment and have their voice heard. The Fmcsa here in this proposal, they're really seeking input on the value and need for the DOT application. We've talked with many people in the industry, including Dave Osecki from Scopelitis and David Robinson, an attorney at Scopelitis, and then many other carriers that are concerned about this. We've sort of vetted it and talked with people. We really agree that this is a fact-finding mission by the Fmcsa. They haven't expressed which way they're going to go for sure. They haven't said that they're for sure going to eliminate it or that they're what changes they're going to make. This really was just sort of a reach out to the industry to get opinions. So let's kind of dig into the details of it a little.
And then also, just so you know, we are going to walk you through how to do this, how to comment at the end of the webinar. We're going to give you a small tour, so don't feel like you have to do that right now. I just wanted to share the link just so that you have it, and then we'll come back to it towards the end.
Okay, so really what this notice that the Fmcsa has put out is asking a question to the industry, and this is the question in sum. Should the specifics of an employment application be mandated by the Fmcsa, or should motor carriers come up with their own requirements? So this is the overall big question that they're asking. Again, this is a preliminary advance notice. There will likely be another notice put out by the Fmcsa, but the next notice will really say exactly what they're planning on doing. And this is the time, now is the time to have your voice heard and to sort of get to have your input on what they will do. They make it clear in their notice that they want input from the industry. And this is the only way in which the Fmcsa can really get feedback is from the industry, is to put out a notice like this and get carriers to comment on it. Again, they have not made any final decisions, and the next notice will probably be a lot more final. So a lot of people have asked why. Why are they doing this? And essentially it boils down to a number of factors. And that is that in 2017, President Trump issued an executive order to reduce regulation. The executive order doesn't say this, but it's pretty well known and widely recognized that Trump expects that for every one regulation that's put into effect, that administrative agencies get rid of two. And so there's sort of been this banking of regulations. And so administrative agencies like the Fmcsa are doing a review of all the regulations to see which ones they can get rid of, to see which ones are burdensome, which ones are still necessary. And actually in 2017, the Fmcsa released a specific notice of regulatory review, and they're saying that this notice is really in response to that they've reviewed the DOT application and that they are seeking input on whether it is valuable. They also cite the Paperwork Reduction Act of 1995, trying to reduce the amount of paper that the industry has to deal with. This really is expressed as they're evaluating regulations to eliminate burdens, and they seek public comments from the industry asking 11 specific questions, really to gauge the industry's opinion. So those are the reasons why. All right, so it's important to note here that the Fmcsa specifically says that they cannot eliminate the requirement for a driver to provide 10 years of prior CDL employment history. This is a statutory mandate enacted by Congress, actually through the Commercial Motor Vehicle Law of 1986, and that's the citation to the statute, 49 U.S.C. 31303. So Congress enacted that requirement. And the FMCSA, which is an administrative agency, cannot change that. There's been a lot of comments about how burdensome this 10-year requirement is. We happen to agree with that, but unfortunately, this will not eliminate the requirement that carriers have to, at some point in the process, obtain this 10 years of prior CDL employment history. And so that's really notable here that requirement is not going away. Also, in the notice released by the FMCSA, they made several assumptions, and they state those assumptions in their notice, and they really are asking for you to comment on these assumptions and whether they're accurate, whether they are headed in the right direction. So they assumed that carriers would still ask for date of birth and social security number on the application. As we're going to talk about later, we believe that carriers wouldn't actually be able to ask for those things, and we'll dig into that here in just a minute. They assumed that carriers would still ask the nature and extent of a driver's experience. And while that's true, what we're going to talk about here in a little bit is how carriers would really still be limited in, if these regulations went away, how they would be limited in the nature and extent of a driver's experience that they could get on an application. And then the FMCSA assumed that carriers would still have other items on their application today that they would still be able to include those. And as we're going to talk about, we think other EEOC laws and state regulations and state and local municipality laws will really prevent that. So other key things to note, they're not eliminating any of the other requirements in the regulations. So for example, you will still have to get verifications of employment for 3 years, which includes prior employment, accident records, and drug and alcohol records. You'd still have to go get an MVR. You'd still have all the same DQF requirements. So while they're proposing changes to or potentially eliminating the application, none of the other requirements would go away. Okay, so let's talk about some of the potential implications. Without a DOT-specific application, we think hiring gets more difficult for our carriers. And these are the key points on how it gets more difficult. Ban-the-box jurisdictions will gain control. So what that means is that states and municipalities will now govern what questions can be asked on an application, and that changes from jurisdiction to jurisdiction. We know carriers hire all over the United States, and so one application would have to either comply with all of those ban-the-box jurisdictions, or it would have to change based on the jurisdiction that they're in. Another really important thing here to note is that ban-the-box state laws would prevent violation history questions. So any questions surrounding whether a driver was convicted of certain offenses, including DUIs or other motor vehicle laws, those would likely be banned across ban-the-box jurisdictions. And then there's sort of this potential out there for restrictions of even getting accident info, particularly if the question was focused at obtaining whether the driver was at fault for the accident. If they received a citation, those questions would likely be prevented by ban-the-box jurisdictions. So what it boils down to is that ban-the-box will really prevent a good number of questions that employers are interested in and that employers ask today on the application. The law that currently exists created a lot of certainty throughout a DOT application. You know what you can ask, and you can go ask it because it's federally mandated, and those federal mandates supersede these state ban-the-box jurisdictions. So you can ask those specific questions because they're now required by the FMCSA. If that goes away and they're no longer required, these questions suddenly would go to the individual jurisdiction and the laws that are enacted in those jurisdictions and be governed by that. All right. So another way in which the implications of this would have is that we would run a much greater risk in asking for a social security number and a date of birth on an application. Most employers now and that are not in the DOT industry don't collect this information on an application. And in fact, California's new privacy law would actually prevent employers from asking this. If you were hiring in California, you would not be able to ask Social Security number until after you hired an individual. But date of birth runs a really big risk for EEO claims, specifically ADE claim or age discrimination in employment claims. And so just by virtue of asking that information, you would run the risk of a failure to hire claim based on the age of the applicant. And when I was in private practice, I handled several ADE claims based on a failure to hire. So most experts would agree you would not want to ask either a Social Security number or a date of birth on an application unless you were required to do so. However, we know that most carriers need a Social Security number and a date of birth to run these required checks. And if you weren't able to get that on an application, you would have to reach out to a driver after getting the application before you would be able to get this information. Oftentimes, you would have to give them a conditional offer of employment before you were able to get this information. And so that would really lengthen your time to be able to run MVRs, background checks, things along those lines. Another key I want to hit here, we'll talk a little bit more about that later, but another key point I want to make here is that 3 years of employment history gets more difficult. Could you ask for that? Absolutely, and you would certainly want to if this rule went into effect. But the reason why it gets more difficult is finding the gaps in employment, because the experts in the industry really don't recommend that you get dates of education and or military history. If the mandate goes away to provide that, these things generally are not obtained for the exact same reasons: increased EEO concerns, increased risks of a lawsuit just by virtue of having those dates, because you assume that somebody is of a certain age if they have certain military history and dates in their application. And it's also key here, I want to point out and mention, we work with a lot of job sites like Indeed, and they take compliance very seriously with EEO laws. And places like Indeed would not even link to an online application if it had these questions in it. In fact, we run up against it already with a DOT compliant application, and we have to go back and work with the Indeed people and say, no, look, to show them the regulations, show where it's required, and then they always agree and say, oh, okay, we can now link to it. But we know that a lot of our carriers spend thousands of dollars with job sites like Indeed, and it wouldn't matter, they still wouldn't link to your application if you had questions that they believed violated EEO laws. So, yeah, I wanted to ask here if Tim would talk a little bit about how we at 10th Street will be prepared if the Fmcsa follows through with the proposal and eliminates the application.
Great. Thanks, Shannon. So I think just briefly what I want to kind of talk through is explicate out some of the likely implications, sort of consequences going forward if you think about it. And I think the right pattern to use here is to think about how Ban the Box affects your recruiting process day in, day out. You can't ask those questions at the initial application, but you can ask them when a candidate gets deep enough into your process. The complexity, of course, is that deep enough into the process in some states means after they've had an interview, in other states it means after a conditional job offer has been made, et cetera, et cetera. But if you take that kind of pattern and you expand it to say, hey, I can't ask you about your violation history. I can't ask you for your social and date of birth until deep enough into the process, the complexity in your recruiters gets really high. And also there's a question about mechanics. How do you go about asking for those things? And one of the things we take pretty seriously here is, we're really focused on keeping the system aligned with your processes, just like our interests are aligned with yours in terms of, what makes the most sense overall. And so what we would do is, our plan is if the process goes forward and they do remove this requirement, there'll be a method where you can subsequently request from the driver deep enough into the process, hey, I've made you a conditional job offer, et cetera, and I can go forward and say, come follow this link, supply me this additional data. It doesn't change the complexity of, hey, a lot of the background check processes that you guys rely on day in, day out are searched based on name, date of birth, and social. And so that means from a process perspective, the background checks that are stayed early in your process are going to go later and deeper. And we all know that every time you go back to a driver and ask for additional data, that's going to up your dropout rate and drivers that go into unable to contact. And so it's going to it has the potential to be really, really messy operationally. But I think from a technology standpoint, we're going to do whatever we can to mitigate the consequences. But to be really clear, we think the consequences are going to be material, and that's kind of why we're making this big push.
Yeah, that's great. Thank you, Tim. And then I also just want to say that our interests are aligned with clients, and that we want to eliminate those burdens. But we'll be here if they put this into effect to help you with the compliance issues, to help you with the ban the box issues and the EEOC issues, and so as these issues arise, we'll do what we do now, which is that we'll keep you apprised of the compliance issues that change throughout the country as these laws change. And so kind of leading into that, I wanted to talk about ban the box laws and just show you guys. So this was ban the box in 2013. There were 2 states and 2 cities and counties. So not very many, but to show you how this has spread across the country and how it will continue to spread across the country is our next slide, which is that today, now in 2019, there are 12 states and there are 18 cities and counties that are affected by ban the box laws. Each and every one of these laws is different in some respect, but we get notices almost monthly with updates, like specifically New Mexico is a recent one, Westchester County is a recent one. Let's see. So some of these, Kansas City was not very long ago. So we update these as they come out. We evaluate these laws, we look at them, and so we stay on top of these. Right now, you can only ask certain questions because they are a part of the Fmcsa regulations, and without this requirement, in all of these jurisdictions, those would go away. And in many of these jurisdictions, they talk about before you can ask any criminal information or any criminal details about convictions, you have to first give a conditional job offer. And what that means is that you're actually offering the individual a job with your company and saying, you have a job with us conditioned on these things, which would be passing a background check or, certain things. But then you have to have a lot stricter requirements set out for what those conditions will be. Otherwise, you would have to hire the individual. So more on these ban the box stuff, I'm going to have Leah post a link to the NELP guide. So this is the National Employment Law Project, which contains lots more detail about these ban the box jurisdictions. It goes into detail about what the jurisdictions are and what the specifics of each and every one of these laws are. Okay, and then just to point out, if there's no social security number or date of birth, it makes it extremely difficult for you to obtain certain reports. So in looking through our processes, we can tell that you need date of birth for MVRs, that most states will require date of birth, that you need date of birth for PSP, you need date of birth for criminal history. You'll need a social security number to run SIDLIS reports. You'll need a social security number to run the DAC. I believe for the work number, you also needed a social security number. And then most verifications of employment, you need social security numbers. And oftentimes, even if you're verifying employment directly with the other carrier, the prior employer, they look up information based on the social security number. So, really there's no good way to get around the need for this information. You have to be able to verify that you are providing a report on the proper person, and driver's license numbers change. Name searches are historically show just an absolute cannot verify that it's the accurate person that they're talking about, that you're pulling a report on. So, you really would not be able to get around obtaining a Social Security number or a date of birth to run these reports. So that's something that's just really key to point out. All right, so we have, like I said, talked with several people in the industry, and I just wanted to point out some of the comments we've seen and some of the comments we've gotten. Specifically, the in-house counsel over at CREAT, we've worked very closely with, and he pointed out here, and I thought this was a great comment, that any burdens that would be lifted by the elimination of the application would be grossly disproportionate to new administrative burdens, compliance obligations, and costs that motor carriers would be faced with. So I think that is been talking with a lot of people in the industry and a lot of other carriers. This seems to be everybody's thought on this. All right. Also, in talking with the General Counsel of ProFrac Services, they also said that it would be more difficult to perform MVRs and other background reports, and that it would have a negative impact on operators or carriers in the industry if they couldn't obtain this information. But also, it disenfranchises and isn't good for drivers. For wage earners, it would take longer for them to get jobs. So I think that was a really great comment by Brian. And then this is part of the comment that 10th Street's going to be providing. We will have that finalized. We're putting the final touches on it right now, and we'll have that finalized and released. We're probably going to link to it in the blog post so that you can see 10th Street's entire comment. But the key here is that when you require the information up front in the application, carriers can quickly evaluate a driver's suitability for the job, and they can more quickly process the application. Since none of the other regulations are going to be eliminated, eliminating the application actually eliminates the fundamental means which carriers use to obtain the information necessary to comply with all the other regulations. So like I mentioned at the beginning, there were 11 questions in total posed by the Fmcsa in their notice. I have 4 of them listed out here. You can see our blog post for our answers, and I think Leah is going to put that blog post out here in the chat section here in just a minute. But go look at the rule, go look at the notice to see all of the 11 questions. But I think key here is pointing out again that the Fmcsa is really on a fact-finding mission here, and so they ask, how would the elimination of this regulation impact a carrier's ability to hire safe drivers? The second question is, if it was eliminated in its entirety, if it's not eliminated in its entirety, what elements should be retained so that you can go get the information that you need? Also, they ask just point blank the question of, would you still have an employment application? And if you would, what information would you not have in it? So what is burdensome to you? And then what I really like is a question they pose about the specific impacts on small carriers. We know that any changes in the regulations have a bigger impacts on small carriers. They have a lot less resources to comply with regulations. And so you can go to our blog to see our answers, but I would encourage you, whatever your position is, to go give your feedback to the Fmcsa. This is the only way they can really gauge the industry. Okay, so like I said, make your voice heard. You need to comment by May 7th. That's a week from today. So this is really key. We don't have much more time. There's been no notice that the time will be extended for other people to comment on it. I think this regulation change, this proposed regulation change, has really flown under the radar, and not a lot of people are really aware that it's happening. So we really just wanted to let you know what's happening so that you can get out there and make your voice heard. And so Leah is going to show us how you can go comment. And if you go to our blog, the blog post on this topic and click on that. So where it says the FMCSA wants your input on the need for the DOT application, you can click on that, and at the bottom of that, there you go. At the bottom of the very first section, right there, it says you can do so at this link, and it'll take you directly to the regulations.gov website, and that's where you comment. They have made it really easy and clear on how easy it is to comment, and this is all you need to do. Put in your comment here. You can, if you choose to, if you don't want to type it in here, you can upload a file and just hit that button and link to the file that you want to upload. You do have to put your first and last name. You can put anonymous, and we've seen a lot of anonymous comments, but it's really more valuable if you say who you are and how this regulation will affect you. And so other little tidbits here, if you scroll up and click on that very first link right there, this will take you to the language of the notice. You can see exactly what the FMCSA is proposing. It's the same thing that was released in the Federal Register that we posted in the handout section, but you can look at it right here on this website as well. If you click on that Open Dockets folder link, here you can see all the supporting documents, and then you can see the comments. So there have been 283 comments so far. There are, which is great. That was just recent. Up until I think about 2 weeks ago, there were only 8 comments. Before we released our blog, there were only 8 comments. I'm not going to say it was attributed to our blog, but certainly getting the word out doesn't hurt. So go comment and make your voice heard. And so if you have any questions about tips that, how can I submit an effective comment? I believe, posted in the handout section it's actually the regulations.gov tips for submitting effective comments. So you can click on that and take a look at what the FMCSA says they would like to hear. But really what it says is that you need to read and understand the proposed regulatory action that you're commenting on. If you're on this webinar, you're already ahead of the game. They really like it when comment gives sound reasoning, scientific evidence, or specific details of how you will be impacted. It's really good to support your comments with data, information, credentials that you have, experience you have in the industry, and that you provide examples of how you specifically will be impacted by these regulation changes. And then always give constructive feedback. They're going to give a lot more weight to respective and good feedback than they are just badgering or anything that is maybe not the most professional. So those are tips for submitting effective comments. And I think now we can take questions. So write in your questions. We'd love to hear from you. If you have comments that you'd like us to hear, great. I'd really like for you to go put them on the FMCSA regulations.gov website, but we, voice your comments here as well. But we're also willing to answer any questions that you all have.
Okay, so it looks like we've got a few coming in. Thank you guys for your patience, and thanks for writing your questions in. So regarding violation history, this is one of our first questions. Would the DQ requirement to obtain the certificate of violations cover the violation history and override local and state ban the blocks laws?
I think the answer on that is probably not, right? The cert of violations is something or at least not in time to really help you on the recruiting process, right? You would still be able to get it as part of the onboarding event, right? But the ban the box laws are going to prohibit you from asking about those violations until you've made a conditional offer or until you had an interview, whatever the requirements of those individual ban the box laws are. And so you would be able to get it. All this information is not going to prevent you from getting what you need. It's just a matter of process and timing of getting it late, and what does that do to your process?
Yep, I would completely agree. Even though the other regulations will stand, that won't allow you to ask it on the application itself.
Okay, thanks. Thanks for that question too. And so there's a couple of questions. A few people are asking, what does the FMCSA expect to gain by removing this requirement? What's the benefit of removing it? What's the benefit of eliminating 391.21?
So I think what they're really doing here is they're seeing what regulations they can eliminate. They're really doing an evaluation of what is burdensome to the industry, what is valuable to the industry, and what can they get rid of, and what can't they get rid of.
Okay. And so this person's asking how will they be able to get the 3-year drug and alcohol and accident background checks without this information? Brett.
That's a great question. I think that that's sort of why we're raising awareness to this issue, is that it makes it a lot more difficult for you to get. So you can still get prior employment history on the employment application. It's no longer mandated that it be on an employment application. So you could still ask for it. We think that drivers are going to be a lot less likely to provide that information, but along with the Social Security number and date of birth up front on an employment application if it's not mandated. So, you would have to follow back up, learn your process after receiving the application to get that information to then go verify it. So that's sort of one of the reasons why we're raising awareness, because we think it creates more steps for you in a less efficient process.
And to add something that's probably really obvious, but since it's a specialty of mine, the system that all previous employers are using, right, whether it's 10th Street Exchange or whether it's an in-house system, virtually all of them are indexed off of social. And so the first question we had was, hey, can we do a request for previous drug and alcohol, previous safety history without a social, with some alternate identifier? And the answer is, there's not any other really good identifiers, right? And B, the system on the other end, the people that you're going to be requesting of they're just hardwired to require name and social, or name, social, and date of birth, right? Whether it's a previous employer looking up the previous employment in some in-house system, or whether it's HireRight looking up on a DAC report, or AMVA looking up on a SID list. And so while it's potential that those systems could change, that's a years and years long process to where social isn't the absolute key to all the background checks that most of our clients are using early in the hiring process.
Yeah, I would agree.
Okay, and here's a question. Is it possible that they're moving forward to eliminate the DNA due to the clearinghouse requirement where carriers have to enter into a website by 2023?
I really think the two are completely not connected. The Drug and Alcohol Clearinghouse, it will start supposedly at the end of this year. They say they're on track. And, that will be a mandatory requirement for certain parties to report, and then for other parties for carriers to then go check and hit against the clearinghouse to get that drug and alcohol information. And I really don't think that clearinghouse, they've made it clear, is not going to change the effects of 391.23, which is that you go to the previous employer and get any drug and alcohol information. So it will make it easier and quicker to get that information, but it doesn't really change the obligation to still conduct that verification of employment with that information.
Okay. If a driver refuses to provide this information, say they still ask for it and a driver refuses, it's no longer required, could they then be liable for discrimination if they're not hired?
Okay, well, I'm just going to say really quickly that I have to be really careful about not giving out legal advice. I can't represent people in companies without specifics and having a relationship built. But I would say, so I can't tell you whether it would be discrimination or whether they would have a claim. But I can say that if you don't have the information about their age, it would be really difficult for them to say that you discriminated against them about their age. But if you do have information about their age, whether you get that up front on an employment application, then the likelihood that you would have a claim for failure to hire them because of their age is a lot higher. However, carriers have always really been protected from those kind of claims up until now because they've had this requirement that's in the Fmcsa regulations, and so that's been a really good, clear defense to those kinds of claims, which is just, hey, we have to have this information to be compliant.
So it ties into the next questions. If they do eliminate this, how will it affect, will they have an increased litigation? Will there be an increase in litigations that carriers may face?
Absolutely. So that's, I think, one of the other reasons why we want to bring all of this to your attention, and that is that asking certain information on an employment application will be up to each individual carrier instead of what is mandated by the DOT. And we know right now is that the DOT mandates the minimum guidelines and that carriers often ask more questions. But with these minimum requirements in place, that you're sort of guaranteed to get that information right now. But a lot of those things will go away if the regulations don't require it. So asking for social, asking for date of birth, asking for violation history, like we've talked about, it's going to go away. But if you do ask for those things, if you say, oh no, I'm going to take a risk out there and do it, that's going to increase your risk. And so the other thing to note is that this will be sort of a new test area for plaintiffs to say, hey, we think that you can't do this. So if you still put your date of birth on there because you need it, or if you still ask for the social because you need it, and there's no law that would say you absolutely cannot ask it. It's just that the risks of asking it would dramatically outweigh the risks of not asking it. So if you put it out there and say, hey, we're still going to take the position that we can have it, I think a lot of plaintiffs are going to say, oh, no, now we're looking for areas where we can sue carriers and get a payout versus just go drive. But certainly, when I was in practice, I had a lot of ADEA claims. They are definitely increasing. Litigation in general is increasing across the country. And so anything that opens up the risk area for carriers to obtain, for plaintiffs to sue carriers or sue companies in general, they're going to find a way and they're going to do it.
Okay. And so have you heard, or have we heard from or gauged what insurance companies might think about this proposal?
That's a great question. We had this question posed fairly early on, and frankly, I think that it really doesn't affect insurance companies. They are going to require carriers get the same information regardless of how they get it. So an insurance carrier is still going to say, we want to see the MVR, we want to see the verifications of employment. We still are going to require you to get all of this information because we're only going to insure safe drivers. They don't really have an interest in it because they don't care how you get the information. They don't care that it might take you longer to get the information. They don't care that it's going to increase the costs to carriers associated with getting the information, or that it's likely to extend and delay the time from when you first get an application or a lead-in to when you finalize it. They don't really care about that. They're just saying, hey, you're going to have to get this information. So I don't really think that insurance carriers are affected by it.
Okay, thank you. So what time frame are we looking at until this potential elimination takes place, if it does?
That's a great question, and it's just really uncertain at this point. I think what will likely happen is that the Fmcsa will take comments, they will evaluate them, they will look at them, they will probably take some time before they decide what they're going to do with them. They, again, have made it clear that they don't know, but they've not expressed any clear indication of what path they might go down. But the next time we hear from them on it, they probably will have expressed something that they're going to do. They could just leave it alone. They could decide that they've gotten enough comments saying, no, we like the application, we want the application. They could leave it alone and not do a thing, not take any action. Or we could hear from them again in a few months saying, no, we are going to make these changes, or we're going to completely eliminate it. But, it's sort of hard to tell. It's on the Fmcsa's timeline.
Okay, great. And that, again, ties into the second question. It's kind of a follow-up question. Is there a chance that the proposal can be dismissed after so many motor carriers provide their thoughts and concerns about how it can have a negative impact to their process.
Absolutely. I think that the more comments they receive to gauge the industry opinion on this, the better. And that's really what will guide their next action, is how the industry feels about it. If it's a benefit to the industry, I think that I would hope that they will keep it around. If they get enough people commenting on it that it's a benefit to the industry, I think that they will listen. So yes, there's definitely a chance if enough motor carriers say, we like this, we want it, that they will not do anything and just keep it around.
Okay. If there are any more questions, now is your chance. Go ahead and write in.
We really appreciate all the questions and all the interest in this webinar. I appreciate you all joining us today. It's always a pleasure to get to interact with our clients, and so please, feel free to comment. Please go to the Fmcsa website and comment and leave your comments.
Yes, make sure you leave your comments. Make sure you download the handouts that we put into the handouts of your GoToWebinar control panel, and then in the chat, make sure you go hold of those links if you haven't had a chance to link to them in your browser so that you can look at them after the webinar. We have the how to comment, the NELP guide, and then the blog post as well if you wanted to be able to review that and review the answers that we provided to the questions that we were discussing here in the webinar. It also has a link to the comments page, the regulations.gov page. So, okay, great. Thanks everybody for joining. We really appreciate your time. I know you guys are busy, and it just means a lot that you're here with us, and we appreciate you.
Absolutely. Hope that you've gotten a lot of valuable information today. And if you have any other questions or want to reach out, please feel free to contact your account manager, and we will field those questions and see if we can get you the right answers. Or, like Leah said, you can still comment questions here on the webinar, and we'll get to those if we haven't answered your questions. So thank you all so much.
Thank you. Have a great afternoon.